All right. Good morning, everyone. Welcome. Thank you for joining me this morning. This is part 2 of our Sexual Harassment in Oregon K through 12 Schools webinar series relating to the new Title IX regulations and how we can get our Oregon districts ready and prepared for the August 14th deadline for implementation. If you missed part 1 of the series on Tuesday, we have recorded it and we will be posting those shortly on the website, so you'll be able to access both of these. Additionally, if you have any questions throughout the webinar, you can submit those in the question box and I'll do my best to answer those as we go or at the end if we have some time left over. So my name is Kate Hildebrandt. I'm a Civil Rights and Title IX specialist at the Oregon Department of Education. You can reach me by email or by phone at the numbers listed. My role is to support districts throughout Oregon, as well as students and families, in understanding their civil rights related to sex, gender, sexual orientation, and gender identity. So if you have questions, if you want to brainstorm, my role is to be a supportive resource for everyone, as well as to provide training and technical assistance for districts and for students as well. This webinar is being put on by the Oregon Department of Education. Our goal is to support students, families, youth, schools, and districts in making sure that all of our students are able to achieve their goals, to get a well-rounded education, and to go on to success post-graduation. A big part of this for us is our education equity stance, which means that we want to look at how our policies, procedures, and all of our educational practices are impacting students, especially students from historically and currently marginalized identities, and seeing to how we can support that and how we can make sure that, again, everyone gets an opportunity for education and success. So before we get started, just a few disclaimers from us. One, that this webinar series is not completely exhaustive of the new regulations and their requirements. This was a 2,000-page document with a roughly 2,000-page preamble following the regulations. So know that there's a lot of different things in there. We're doing our best to cover the biggest stuff and as much as possible. But if you have technical questions, don't hesitate to reach out. We also know that this webinar is not intended as legal advice, and we absolutely encourage you to consult with legal counsel and work with them before making any policy or process changes. Also, again, know that ODE is available to support you with technical assistance and training following these webinars, so you can reach out to me following this for training or for questions regarding these Title IX regulations or civil rights more generally. And if I'm not the best person to support you, I can connect you with someone at ODE who can. So let's recap very quickly some of the things we talked about on Tuesday. We showed on Tuesday that there are some major changes in the new Title IX regulations as they've been released, and we talked about some of them on Tuesday. Specifically, we went over the new definition of sexual harassment, defining the scope of jurisdiction. We went over some issues of supportive measures and some notification options, as well as walked through the new and specific policy process and informal processes as allowed. Today, we're going to be focusing on the things that we weren't able to focus on Tuesday. So we'll be looking at specific policy requirements, notification requirements, and training and personnel requirements. Also, as we talked about on Tuesday, there are many things in these regulations that are going to stay the same. The first and the biggest one is that students are still entitled to an education free from sex discrimination and sexual harassment more specifically. The second one is that all K through 12 school employees must still report sexual harassment. Again, you might have seen some of those changes in the media about that not all employees have to report it, but that's more specific to higher education. In K through 12 schools, all school employees are still required to report sexual harassment to the Title IX coordinator when they know about it. Also the same, schools still need to have a designated Title IX coordinator and need to make information about who the coordinator is and where to find their contact information easily accessible. We'll talk more about this today. Also, students are still allowed to have an advisor of choice, and that's now specifically in the regulations that students need to be informed of that right, or employees. I'm saying students, but this applies to students and employees as well. All complainants and respondents in this process are allowed to have an advisor of choice, so they need to be notified about that option, and we need to make accommodations regarding that. Also, what's the same, many Oregon laws are still going to apply. We have many specific laws in Oregon relating to sexual harassment, as well as sexual abuse, mandatory reporting, and a lot of these are going to overlap and build upon these Title IX regulations. We at ODE are planning to do a webinar later this summer, probably around August, that will specifically dive into the overlap between all of these Oregon laws as well as Title IX and how you can kind of understand and implement your obligations so it can flow very smoothly and you're not missing anything there. On Tuesday, we also walked through the new steps of the grievance process. So all the way from actual knowledge when you know about potential sexual harassment to the complaint, investigation, and decision-making process, as well as what appeals and sanctions and remedies look like. So now we'll be talking about how all of these things are going to look in the personnel and policies that go along with these. So today's agenda, we're going to start off talking about the people. Who's involved in the K through 12 Title IX responses? What are their roles? What are their obligations? Then we'll talk about policy. We'll look at specifically what's required for policies by August 14th and talk about some supporting documents and processes for those policies. Then we'll get into some process issues, and specifically, how will processes shift and what are some best practices that we can look at in implementing these new regulations. We'll also look at some frequently asked questions that we're starting to see around these new regulations, things like, for law enforcement, what are some best practices when there's a concurrent investigation? What are some best practices for a smaller district, especially some of the very small districts we have in Oregon? How do I work with parents and what's their role throughout this process? So we'll talk through those towards the end. So let's start off with the people. In the new regulations, there are 5 specific roles listed for personnel in districts. The first is the Title IX coordinator. That's going to be the biggest role, and we'll start off focusing on that one. The Title IX coordinator's role is not new. That's something that's been required for a long time, and this doesn't necessarily change too much about the Title IX coordinator's role, but it adds some specifics and outlines more specifically ways that they're involved in the grievance process, as well as before and afterwards. The other 4 individuals mentioned are an investigator, a decision maker, an appeals decision maker, and an informal resolution facilitator. Important to know for all of us is that under the regulations, the Title IX coordinator can be the investigator, so they can serve as an investigator in some or all cases. Also, an informal resolution facilitator is only required if an informal resolution is offered. Remember that you're not required to offer an informal resolution. What this translates to is you have a minimum of 3 individuals who need to be designated in any school district. So you need to have at least a Title IX coordinator who can serve as the investigator, as well as a decision maker and an appeals decision maker. The investigator, decision maker, and appeals decision maker need to be different individuals for every case. They can also be more than one person. You could use a co-investigator model. You could have a panel of decision makers and a panel of appeals decision makers. So while 3 is the minimum, I think for many of us, it's going to be more than 3 individuals. We'll also talk why you're going to want to have multiple folks trained in these positions so that you can have different folks serving on different cases if needed. So let's start with the Title IX coordinator. This is, again, not new to most of us. We've been required to have Title IX coordinators for a long time, and for the most part, we all do. The Title IX coordinator, their role is to oversee overall Title IX compliance. And remember, that's not just sexual harassment. as most of us in K through 12 know, we've associated Title IX with athletics, and there's many things that we need to do for Title IX athletic compliance. So the Title IX coordinator is probably going to have a role in that as well as in things like Title IX compliance related to admission, to career and technical education, to single-sex programs, a lot of different other aspects. Relating specifically to sexual harassment, the Title IX coordinator needs to respond to all actual notice, coordinate supportive measures, coordinate the implementation of remedies and supportive measures, and keep records. These are all things that are listed specifically in the new regulations that the Title IX coordinator needs to do. Now, relating to supportive measures, I want to touch on this one a little bit because in many districts, the Title IX coordinator is not necessarily the one implementing all measures, or they may not even always have been coordinating measures in the past. Some schools use their school counselor, they may use principals or assistant principals at the school level. They may also use advocates or partner with external advocacy agencies and have somebody come onto campus sometimes. And so those folks may be involved in coordinating supportive measures. Under the new regulations, the Title IX coordinator is directly required to be responsible for coordinating those. They need to be able to keep central records and to understand, and the regulations are very clear that they need to be involved in those. However, they're also clear that other individuals at the school or district level may be involved in implementing those supportive measures. So if you typically work with someone else, like for example, a school counselor, what would probably need to happen is the Title IX coordinator would meet with the reporting student or reporting employee and talk about what supportive measures can look like. And that could be a conversation as well with a school counselor or with another individual. And then that person could work to implement them. That person would just need to check in with the Title IX coordinator and keep them updated so that they can maintain records and make sure those are being implemented appropriately. There's other things that the Title IX coordinator may do related to sexual harassment. So they may investigate cases. One thing to think about is, should the Title IX coordinator be investigating cases? Is there potentially a conflict of interest that could arise if the Title IX coordinator is also investigating cases? That's going to vary case to case, district to district, and just an important consideration for you to think about as you're deciding at your district level who you want to designate. They may issue notices, and there's a couple of different notices. For example, the notice of allegations or the notice that goes out right when a formal complaint is filed. That's likely going to be sent out by the Title IX coordinator for most of you. However, things like the investigative report or the determination of responsibility, which happen throughout the process, you may decide that those will be sent out by the investigator, by the decision maker, or they could be sent out through the Title IX coordinator. They may also train personnel, and they'll need to be responsible for keeping records of training, regardless of whether they do the training, but they may be the ones implementing that training. This is not exhaustive of what their responsibilities may be or what you may add to their roles under this. But really importantly, the new regulations do really strongly emphasize that the Title IX coordinator needs to be very clearly designated. I've heard other experts talk about this, and this is also my read on the regulations as well. The Title IX coordinator needs to be part of the job title. I encourage you to talk with your legal counsel about what that specifically looks like for your district and whether they're reading that as well. But I really think it does need to be clear who the Title IX coordinator is. So make sure that's a part of their job description and their job title. I'm getting a couple of questions about saying that the handout is not downloading again. And so if that's the case for folks, know that I will be sending out a follow-up email immediately after this to all attendees. So you should get that by 11 a.m. and that will include the handouts in them. So other roles, the investigator. Pretty clear what the investigator does. They're going to do the investigation. They conduct interviews, gather evidence, and they're going to be the one writing the investigative report. Again, they may be the ones sending out the investigative report, whether or not they're doing primary correspondence with the complainant, respondent, witnesses during this process. That'll be kind of a process decision up to you, whether that's going to be the investigator or the Title IX coordinator. And since they could be the same person, it may not matter necessarily. But these are things you'll want to think about in advance with your process. The informal process facilitator. Remember that this is going to be optional if you have an informal process offered as an option, but they were going to want to coordinate the informal process. It's pretty important that the informal process facilitator be separate from the formal complaint and grievance process. And that's, I think, to just increase rapport throughout the informal process and make sure that then, again, if the complainant or the respondent decide to opt back in to the informal process or to the formal process, you're not creating a conflict of interest by having someone facilitate the informal process who then is a piece of the formal process. Then we have two levels of decision makers. And decision maker, the title doesn't necessarily matter. That's the wording that they're using in the regulations. This could be adjudicator, could be hearing officer, lots of different terms that you might use in your specific district. So the decision maker's role is going to be one, to conduct the hearing if applicable. Remember that hearings are not required for K through 12 schools, although you may choose to do them. So they may not be conducting a hearing, but if there is one, they'll be conducting that. They're also going to facilitate that modified cross-examination questioning in the K through 12 world. So that's where we're going to be sending written questions back and forth, and they'll also need to be able to screen those questions for appropriateness. There are several things in the regulations that mandate what is an appropriate or applicable question, so they'll need to be able to make those determinations and then rationalize their justifications for those in the record. They're also going to write the determination of responsibility. We'll go over what that looks like in a minute, but there's a lot of specific things that have to go into the written determination. Then the appeals decision maker, they're going to facilitate the appeal process, including notification, written opportunity to respond, and writing the appeals decision. So these two levels of decision making need to be two separate individuals or two separate bodies. Again, this could be one person or it could be multiple people. It's really up to your district and what your process is best. Just for quick reference, here's a chart of the 5 different roles and which levels of the process they're likely going to be involved in. So the Title IX coordinator, as you can see, is going to be involved in the most parts of the process. And especially because they may be an investigator, they're going to be involved in almost everything, with the exception of actually making the decision or making an appeals decision. However, sanctions and remedies, they're still going to be involved in. They're not going to be deciding what sanctions and remedies are given out. That's for the decision maker or the appeals decision maker, but they're going to be helping to implement those sanctions and remedies and make sure that they're followed. Let's talk a little bit about training requirements, because the regulations do get specifically into training requirements for all of these individuals. So the first thing to know is that schools are responsible for ensuring that all designated personnel receive appropriate training. In the draft regulations, they had a lot of specific training things and were mandating this. However, in the final regulations, they've actually gone above and beyond that and said that they not only must train them, but you actually have to post all of the training materials. So any training materials that you use for any individuals involved in this process need to be posted on the school's website, or if you don't have a website for your school district, they need to be available in the district office for review by anyone whenever they would like to. So those materials need to be fully posted. There's actually a letter on the OCR website, and I'll link to that in the follow-up email that even more specifically elaborates on what training requirements need to be. And that's one of the main reasons why we're going to have these webinars posted on our website, because if you're using these as a piece of your training requirements, then we want you to be able to link to these. Know that using these webinars as your only training requirements is probably not going to meet the requirements. You're going to need to seek additional training, but you can use these as part of those, and we will be posting those. So additional training requirements: you must not have a conflict of interest or biased against complainants or respondents generally, or an individual complainant and respondents. Conflict of interest and bias is a really strong theme in these regulations. They really want to eliminate conflicts of interest and bias from the process. So that's something you should put some time and effort into thinking about with training. How do we train folks on what conflict of interest and bias is, and how do we make sure that that's eliminated for folks? I do like to say that I think we all have bias, and I think it's really hard to fully eliminate those, but what's important is to become aware of them and to engage in some training and some ongoing reflection in training, so we're making sure that we're eliminating our biases as much as we can and that we're removing those to the greatest extent possible from the process. A lot of us have unconscious bias that we might not even realize we're bringing into something. They're also really emphasizing removing conflicts of interest. And I think that's going to be something that districts need to think about a little bit. What does a conflict of interest mean for our district? Is it a conflict of interest if I have a relationship with the student? How much of a relationship? If I have imposed discipline on the student in the past in my role, is that a conflict of interest? Is it a conflict of interest if I have worked with this student extensively, if I am friends with this student's family or this employee's family? So think about that, because for a lot of our districts, that's going to have a big impact, especially in small communities where we've got really tight-knit folks. A lot of people know each other. There's, families, tight-knit relationships. Many people are serving multiple roles. That conflict of interest piece is going to be something you'll want to dive into a lot. And if you have specific questions about that for your district, I'm happy to set up a phone call with you and talk some more about that. So we got a specific question about the role of the Title IX coordinator. If the Title IX coordinator is not the investigator, can he or she then also be the decision maker? The Title IX coordinator, according to the regulations, cannot be the decision maker. The Title IX coordinator and the decision maker need to be two separate folks, and the Title IX coordinator and the appeals decision maker need to be separate. So those are at minimum the three roles you'll need to have: the Title IX coordinator, decision maker, and appeals decision maker, because the Title IX coordinator can serve as the investigator. 2 additional requirements: training must be free of bias and stereotypes. Again, we see an emphasis on bias, and posted to the school's website, as I mentioned. So here's another chart that lists the different training requirements as they're listed in the regulations, as well as who needs to get trained on that. So the top 4 requirements really should be everyone. That's the definition of sexual harassment, scope of the educational program or activity, how to conduct the applicable portions of the grievance process, and that's going to be whichever portion that individual is conducting. However, if you're having individuals who might serve in multiple roles, then they'll need to know about the entire grievance process. And then the last one is avoiding prejudgment of facts, conflicts of interest, or bias. Then they list some specific training requirements for specific individuals. So the investigator needs to receive training on how to create a fair and thorough investigative report. And then the decision maker and the appeals decision maker need to receive training on any technology used at hearings and issues of relevance for questions and evidence. Now, the issues of relevance I mentioned before, there's specific things that can and can't be asked related to those cross-examination questions, or even questions that the decision maker themselves might want to ask of the parties. So they need to be trained on the appropriateness of that in line with the regulations. The technology used at hearings is more speaking to a higher ed context where they're required to have live hearings, but they're also allowed to use technology to conduct cross-examination with parties in different rooms and just have it live streamed by technology. However, again, if you are choosing to use hearings, you might want to do that. That's, I think, a trauma-informed way of holding a live hearing, but still allowing complainants and respondents to have a little bit of space from each other by being in separate rooms, if that's going to help them mitigate trauma or stress of being in that hearing space. So if you're choosing to have hearings, think about what technology you might want to use and then what kind of training you might need so that you can have a really good trauma-informed process. I had an additional question about how much latitude folks have around conflicts of interest, and again, especially for very small districts. We have a lot of districts in Oregon where you have maybe a handful of employees in the entire district, or you have one school or one K through 8 school and one high school. When we're thinking about those, obviously there's a lot of close relationships that can happen in there, and especially a lot of relationships that employees might have with families outside of school when you live in small communities. That all makes complete sense. I think that conflict of interest is going to be difficult in those situations. And one of the things that I suggest thinking about is, are there partnerships you can make with nearby districts or with your ESD so that you can potentially share investigators, decision makers, appeals decision makers, even if you think that there's going to be frequent conflicts of interest. Again, for folks in really small districts, I would love to have more one-on-one conversations with you to hear about what are some of the dynamics, and we can kind of brainstorm together. So don't hesitate to contact. Send me an email. We'll set up a time to talk. So some additional training best practices that I hope you'll think about. Those things on the previous chart are required in the regulations. However, you might also feel that you need some additional training for your districts. One of those things that I would suggest considering is dynamics of sexual harassment and interpersonal violence. And that's because just the definitions aren't probably going to give individuals enough information to make decisions, especially if things like dating violence and stalking and domestic violence, which are required in the definition of sexual harassment, those dynamics can be pretty complicated, and it's not as simple as looking at, was there a physical altercation? Was somebody following someone else around? There's a lot of really complex dynamics that can lead up to, or that can happen instead of those things. So it's important that anyone who's investigating or deciding on cases really understands what it looks like. Other options are trauma-informed interviewing and child forensic interviewing practices. Trauma-informed interviewing sometimes gets associated with, it's a really good process for just making sure that you're getting good information. This is also beneficial for not just complainants who might have experienced sexual harassment or sexual assault, but also for respondents, for witnesses, for everyone. It's a method of just really grounding your interview and making sure you're getting non-biased, accurate information, as well as making sure that you're making the individual feel comfortable, feel safe, that you're honoring what they need in the interview, and that you're giving them information to share thoughts, equity, make sure that they're kind of opting into it fully. Trauma-informed interviewing has a lot of different tenets, and again, that could be a whole nother 1 or 2 day session just talking about that. Child forensic interviewing is also a series of practices that have really been developed with a focus on best practices for talking with children. And because these regulations do apply all the way from K through graduating seniors in 12th grade, there are going to be times where you are absolutely going to be talking to children, and you're going to be required to conduct these Title IX processes with very young children. So thinking about, do we need to train our investigators, or do we need to contract with investigators who have those child forensic interviewing skills, so we can make sure that, again, we're getting the best and most accurate information, that we're not re-traumatizing children throughout this process as we're talking to them. Another thing to consider would be bias reduction trainings. So rather than specifically saying this is what bias is and we don't allow it, going deeper into how can we reduce bias. These could be things like implicit bias training, anti-racism education, and these may be things that you already implement with employees in your schools. So just thinking about how can we make sure our Title IX personnel are additionally getting these trainings and able to connect them to their roles. All right, so next let's look at some specific policy requirements. So in the Title IX regulations, they list 10 specific requirements for a grievance process. This is in addition to specifically required steps for example, what you do when you get actual notice. But think of these 10 requirements as more of an audit for your policies. When your policies and processes are done, you should be able to go through it and say, yep, it meets all of these requirements. Treating complainants and respondents equitably, they emphasize that 2 specific ways you need to be doing this are by providing supportive measures as an option for complainants whenever you have actual notice, and by not implementing disciplinary sanctions on respondents until the conclusion of a grievance process. Requiring an objective evaluation of evidence, requiring no conflicts of interest or bias, and training on that, including a presumption of non-responsibility for respondents, and including timeframes that are reasonably prompt. Again, we talked about those timeframes a little bit on Tuesday. There aren't many specific requirements for those timeframes other than reasonably prompt, with the exception of those 2 10-day timeframes that are a part of the investigation process. You need to describe the range or list of possible sanctions and remedies. So what that means is you either need to describe the range or actually list all of the possible sanctions and remedies. You also are required to do this with supportive measures. So think carefully about this, because if you're just listing them out, you're going to be then beholden to what those are, and you won't necessarily have a lot of latitude for creativity if you want to implement something outside of that. Of course, you can always go back and revise your policies and add to those, but we know that those processes can take a little while. So think creatively as you're writing these policies. What kind of supportive measures might you want to implement? What kinds of sanctions, what kind of remedies could be available in your district? State the standard of evidence. That's going to be either preponderance of the evidence or clear and convincing evidence, and that needs to be the same for all cases. So you won't be designating a different standard of evidence for employee cases versus student cases. It's the same standard of evidence for all Title IX cases. You also need to include procedures and bases for appeal. Remember that you have 3 required bases for appeal, but you can add additional ones as well. You're also not allowed to use evidence that counts as privileged information without written consent of the party or their parent. So that's going to be things like medical records, psychological or counseling records. And remember that here in Oregon, we have advocate privilege for sexual assault advocates. So if somebody is working with an advocacy center and they want to use records from that advocacy center, you'll need to have written consent. And you'll also want to talk to them about what's going to happen, how records are kept, what that's going to look like, to make sure they fully understand what they're consenting to if they're giving over any kind of privileged information. There are also several regulation mandated notices and documents that you're going to want to have templates of and think about how you're going to use in your district. So notice of allegations, that's the thing that goes out right when you get a formal complaint. They have 5 specific things that need to be listed in those allegations. You may also choose to have additional things in there. And one thing to think about is, are there other things we want to add in our notice of allegations to comply with our notice of rights and options document that's required in Oregon under our requirements for sexual harassment policies? The second thing is an investigation report. They don't provide a lot of template information for this. They just say it needs to fairly summarize relevant evidence. However, for your district, I think it's a great idea to have a template for an investigative report, to think about what exactly is that going to look like, especially since it is standard if you have multiple investigators or if your investigator role changes throughout the years. Next, we have a determination of responsibility. So again, this is one of those where they list a lot of specific information, and this is going to, in many cases, I think, be a beast of a document for some of us. It includes pretty much everything that summarizes the case from start to finish. What were the allegations? What was the timeline and the steps? Finding of fact. You also need to have rationale for each of the results. So if there's multiple allegations that are being investigated in the same case, then you'll need to come to a determination of responsibility around each of those allegations and justify that, as well as sanctions and remedies provided for any of that. Now, because we do want to be careful around this, and there were some comments on the regulations that listing out remedies could potentially put complainants in danger if we were to say to the respondent, these are all the specific remedies we're applying. We are switching this person from this class to this class. We are moving them here. We're providing them all of these things. So they changed that in the final regulations. You don't need to list out what exactly all of the remedies are. You just need to say whether or not remedies are being provided, and then you would work that out or maybe list them in a separate document that goes specifically to the complainant or complainants. I had a question about whether we'll be providing templates for notices and investigation reports. At this time, we don't have an intention to provide specific templates. However, that's something that we can look into since it sounds like it might be useful for individuals. Additionally, I would look to other organizations that you're members of. They may be providing some additional templates, and I'm happy to look over any templates that you may have and provide some feedback for you if you have those now. So the next one is an appeal decision. And again, there's not a lot of specific information, but it's just a written decision describing the appeal. You can potentially modify this off of the determination of responsibility. However, you don't need to go through the entire determination of responsibility document again because you already have that. You'll just want to say what's changed, what was reconsidered, what were the appeal procedural steps and the results of those, and if any of those sanctions and remedies have been shifted based on the appeal. In addition to those 4 mandated Title IX documents you'll need to give out at some point, I think it's a good idea to consider having other template documents. Template documents are just a good way to standardize processes and again, to make sure that you're removing bias throughout the process by creating a standardized system and form. So consider template documents around 1, the notification of rights and options document that's required under Oregon law. You might want to consider an advisor information sheet. I found this really helpful when I was doing Title IX investigations and working in those processes because advisors often, they aren't really sure what their role is. They might be making assumptions based off the criminal justice system, for example. And so they might be thinking, this is my role here. I'm going to get to interrupt and object. I especially found when I had individuals who were lawyers or who had been a part of other discussions similar to this, they brought in a lot of assumptions from their professional role or from other types of investigations that they'd been involved in. So having a clear info sheet of this is your role, these are the limitations of your role, and what that means and what all your rights are as an advisor, that's just a great practice so that they can have that known right away. This is also helpful because you are allowed to put limits on the role of an advisor in the process. And by that, I mean, you could put limits on how an advisor can participate within an interview meeting, for example. When I was working in the higher ed context, a lot of us would call this the potted plant rule because we would require advisors to basically be a supportive option, but they couldn't answer for the complainant or the respondent. They couldn't object or stop questioning. They could say, hey, I think, can we take a break for a minute? I'd like to talk to this person. Or they could say, it seems like this is a really difficult question. Is there anything I can do for you? They're here to be a supportive person. They're here to listen. They might be taking notes so that the complainant or respondent can be focusing on the interview or the meeting. But their role is not to necessarily be advocating for that person in the meeting or to be answering for that person more accurately. So think about what limits you might want to put on that and how to convey those. You're also maybe going to want to consider email templates for contact information around supportive measures, sanctions, follow-up, different things. I think it's a good idea to sit down as a district with personnel who are going to be involved and with your legal counsel and brainstorm what kinds of templates might we need and what do we want to put into place now so we can make sure that it's, one, easier for us in the future, but also we're following all of our policies and practices really clearly and without bias throughout the process. All right, let's delve into some process questions. So the first one is around public notification. There's some very specific public notification requirements in the new regulations. And this is a pretty wordy slide, but I wanted to pull it directly from the regulations so you knew exactly what they were expecting. So who needs to be notified? This is who they list as needs to get notification in the regulations. So it's pretty much anyone involved with the school, any applicants, students, parents and guardians in the K through 12 level, employees, as well as all unions and professional organizations. And in Oregon, where we do have a lot of union and professional organization representation, know that you're going to need to notify them as well. What do you notify them with? First, Title IX coordinator's name, office address, email, and phone number. So you're going to need to have all of that information available. Oftentimes when I go to websites or when I'm looking in handbooks, it might be some of that right now. So they might say the Title IX coordinator's name and just an email address or just a phone number. And that's been considered something that you could do in the past, but know that now they're specifically requiring all of these: name, address, email, and phone number. And that needs to be very clear. You also need to notify everyone that the recipient does not discriminate and that it abides by Title IX. So if you have a notice of non-discrimination statement on your website, in your handbooks, just look at this and see if there is maybe something you want to modify based on this new requirement. Do you want to specifically include Title IX in that, or do you want to create a separate statement to comply with these Title IX regulations? Another thing that a good colleague of mine frequently points out that I think is a good point is that often those non-discrimination statements say, we will not tolerate discrimination, but notice that here it specifically says it needs to say that the recipient doesn't discriminate, i.e. the school or district doesn't discriminate. So it's great to not tolerate discrimination, and you need to also be saying, and we don't discriminate. Also needs to be prominently displayed on the website and in any published handbooks. So a couple of best practices that I would consider for websites as well as any of your published materials. For websites, one, I think it's a good idea to link from your homepage, either from a drop-down menu, or maybe you have a non-discrimination notice as part of your footer on your web page with links to a different page or something similar. Basically something that could be easily discoverable. So if you have a drop-down menu that says non-discrimination, for example, something that easily linked. Another thing, I think it's a good idea to use both Title IX and sexual harassment, as well as any other terms that might be more familiar to your communities. If your school in the past has tended to use the term sexual misconduct, for example, continue to use that as well, because what you want to do is make it easy for students, parents, employees, anyone in your community to be able to find what they're looking for. Especially knowing that if someone has experienced an incident of sexual harassment, that's a really stressful and traumatic time. And it might be difficult for them to go mining through your webpage or through your student handbook to try to find this information and decipher it. So make sure that it's really clear, really accessible, easy to find. I also think a good best practice is to use a central standard email address like Title IX or non-discrimination at whatever that is. That's also useful if you might be changing your Title IX coordinator, especially in printed materials. So if you print your handbook and then halfway through the school year, your Title IX coordinator changes, you can just switch over that Title IX email address to that new person. And that way, the name of the person might not necessarily be accurate, but the contact information will still be going to the right place and they'll still be able to get in touch with them. Also, again, making sure that you describe the process in plain language. Sometimes policies can be confusing, and I know we try to do as good of a job as we can to both comply with all of the different policy requirements as well as make it clear. But I think it's a good idea to explain at least how to contact, what the first steps are in plain language, so that someone, a student, a parent, anyone who's experiencing any kind of stress or who just might not be familiar with policy language is accessible in that way. Another thing to check your search terms. If I go to your website and I go to that search bar and I search Title IX or sexual harassment, your web page with that contact information should come up on the first page. If it doesn't, talk with your IT folks about how you can make that happen. The second thing to check is your hyperlinks. If I'm going to your web page and you have a hyperlink to an email address, one, it's a best practice to also list that email address out. But if you have a hyperlink to it, check and make sure it works. It's really easy for little things to get changed in the background and then a hyperlink can get broken. So maybe put something on your calendar that every month, every couple of weeks, every quarter, you're going to go through and check and make sure those hyperlinks are still working. We had a clarifying question about whether a district can have more than one individual as a Title IX coordinator. Great question. So you can have multiple Title IX coordinators. You could have deputy coordinators. A really common practice I see is to have deputy coordinators at the school level. So potentially an assistant principal, an assistant dean, someone there might be a deputy Title IX coordinator and they might be coordinating it at the school level. However, you still need to have one centralized Title IX coordinator who's responsible for centralizing all of that information. And the reason is because you want that person to be able to look for patterns, to look for, are there environmental patterns going on at multiple schools that we need to be aware of? Are we coordinating supportive measures, remedies, sanctions in an equitable way across our school systems? Are there disparities that we're identifying between different schools that we might need to address? So making sure that the central Title IX coordinator is kept up to date and that they're keeping the records and they're looped in on those processes from each individual deputy coordinator is really important. So you could do that through regular meetings. I know at a lot of districts I talk to who have deputy coordinators or folks that act as such, they might just, do regular phone check-ins with that person, or they'll call them every time they get a report to go through that. So know that, yes, absolutely, you can have more than one individual as a deputy or as a Title IX coordinator. You'll just need to, again, have a really clear process of how you're centralizing those things. Concurrent law enforcement activity. Again, another big question that I get all the time from districts and that I think we see all the time, because a lot of our reports may also qualify as criminal activity or as mandatory reporting of child abuse. So if you are reporting something to law enforcement, you are still required to investigate it under Title IX. The regulations say that Title IX processes can be temporarily extended for good cause, but they really emphasize that this is temporary. I pulled this language specifically from the discussion, that's done in those pages before the final regulations in the Federal Register, but I think they speak really clearly to this. They only permit temporary delays, and it says, this provision does not result in protracted or open-ended investigations in situations where law enforcement's evidence collection occurs over a period of time that extends more than briefly beyond the recipient's designated timeframes. This is super important because, as we know, law enforcement investigations can be lengthy, and it depends a lot on the situation for that law enforcement agency, how many cases they've got going on, the urgency, priority, all kinds of different things. But just know that what this is really telling you is you're not going to be able to extend it much beyond what your timeframes are, and those are going to be designated in your policy. Some things you can do in advance to really make sure that those things go smoothly and that you're not butting heads with law enforcement is, one, start developing those relationships now. A lot of you, I'm sure, already have relationships with your local agencies. So start communicating with them now. Hey, These are our expectations. We're going to be in violation of federal law if we don't do this, and that puts our funding at risk. That's a risk for our students. We can't risk that. So here's what we're required to do. How can we work with you to make sure that you can still do what you need to do given what we need to do? Good idea to identify a collaboration point person, potentially even develop a memorandum of understanding where you can outline, these are our expectations, these are your expectations, these are the things that we're going to be in communication about, these are the things that we want to negotiate around for each case, and this is how we will support each other. Just that's a good document that you can look back on and say, hey, we agreed to this. I know that this case is getting heightened and there's a lot going on, but remember what we agreed to. Cross-training each other on your processes, very important. And that's actually an additional piece of training request we've gotten is, can we do a training that's specifically geared for law enforcement on helping them understand Title IX roles and responsibilities? So we'll hopefully be looking at putting out some sort of short webinars, short training about that in the future. Staying in touch regularly, also a good practice. And I'm talking about these for law enforcement, these are good practices for a lot of external partners. For example, if you have a local advocacy or rape crisis agency that frequently works with students and employees in your schools, it might be a good idea to develop a partnership with them, just so they're aware of the rights that individuals they work with may have, and you can be clear on how you're allowed to work with them, what the compliance issues might be. They can then help support processes, help students or employees make reports, help them understand the process. It can be a really mutually beneficial partnership to have. Rights of parents, another common and complex issue. So on this page, I again took some language specifically from the regulations because I wanted you to have that in regards to what they say about the rights of parents. The first one, and this isn't changed from anything in the past, but they basically say that Title IX the requirements of that are not alleviated by FERPA. So where there's a conflict between Title IX and FERPA, what they're saying here is the Title IX regulations are going to prevail. So if you have questions about confidentiality rights for student records regarding FERPA, look to both of these and know that what they're saying here is everything in Title IX that we're telling you have to do should be read as complying with FERPA, that by doing this, you're going to be in compliance with that. The second thing is something that they reiterate throughout the discussion. Nothing in this part can be read in derogation of any legal right of a parent to act on behalf of someone. Now, because most of us are dealing almost exclusively when it comes to students with students under the age of 18, that means we need to look at the legal rights of parents to act on behalf of our students. What the regulations aren't quite as clear on as where they fall in terms of the rights of parents of direct notification. So for example, with FERPA, parents are always going to have a right to view their student records. And because these investigations will be a part of the student records, parents will always have a way to be notified and to read about this. However, do parents have a right to receive a direct notification? The regulations in the discussion mostly talk about nothing should be read in derogation of legal rights, but they don't go as far as to say yes or no. What this generally translates to is in most cases, yes, you're going to want to notify parents. However, I think it's a best practice to really think about safety when we're doing that. There are some situations where notifying a parent could put a student, for example, at risk, and they could be at risk of physical harm, of really severe other kinds of harm. So when it comes to elementary school students or younger students of any kind, often middle school as well, notifying parents is almost always going to be a best practice. That's almost always going to be something that we're going to want to do immediately. Notifying parents is also a really good practice because in most cases, they're going to be able to support students, make sure that they have their right to access. It's going to be a really beneficial thing to have in there. So in most cases, even with high school students, notifying parents. However, with high school students, one thing that I like to do is do a little quick safety assessment around that. So say something like, typically in situations like this, we notify your parents pretty immediately so that they can support you through the process. How do you feel about us notifying your parents? And I wrote here, do you have any concerns? But an even more open-ended, non-leading way would be, how do you feel about that? And then what you're going to want to do is look for specific fears or concerns the students have. Do they have concern about physical harm? Do they have concern that they're going to be kicked out of their house or withdrawn from school if their parents are notified? You want to be especially concerned around identity-based harm. And by that, I mean, if you have a student who is part of the LGBT community and who is not out to their parents, and notifying them may alert them that that student is trans or is lesbian or is gay or is part of that community in any way, that could put the student at risk. And if they're telling you that, if my parents find out that I'm gay, they're going to kick me out. That's a big safety concern. And then what you're going to want to do is maybe not do some direct notification. Instead, talk to them about this is going to be a part of your student records. Your parents are always going to be able to look at that. However, let's make a safety plan around that and when that happens. You'll probably want to work with a school counselor. You'll want to think about if there's other advocacy agencies or other folks you want to bring into that safety planning process, and then just clearly document it. We made a safety-based decision to not do direct notification in this case, and this is why. You're also going to want to assess, do we need to do any follow-up? Is this maybe even triggering my mandatory reporting responsibilities because I'm hearing about abuse that might be going on in the home or strong risk of abuse? So again, I think these are decisions to talk about with your legal counsel, talk about as a school, but I would really caution you to think about this safety assessment and safety planning process, because while parents, for the most part, we would hope that they're going to be supportive of students and that they're going to be an ally to their student throughout the process, we know that's not always the case, and we want to be conscientious of that and not necessarily, we don't want to deny students their rights just because their parents are not going to be supportive or might prohibit them from doing that. Record keeping. So you're going to be required to maintain records for 7 years. Records of all of these things, each incident, all of the different notices you gave, all the steps. You're going to want to also notify if you have actual notice and it doesn't proceed to a formal complaint, you still need to keep records of that and why your response, any supportive measures, anything you did is not deliberately indifferent. There's a specific justification requirement. Even if it's not a formal complaint, a formal grievance process, you still need to keep records of the informal resolution, as well as materials to train personnel. And like we talked about, those need to be posted on the website. Working with unions and employee organizations. We're running short on time, so I won't spend too much time on this, but I will just say that your collective bargaining agreements need to comply with Title IX. Some common things to look at, but definitely not the only things to look at in those, are the standard of evidence. Remember, you're required to use the same standard of evidence for employee and student cases. So if you require a specific standard of evidence in your collective bargaining agreements, one, it needs to be either preponderance or clear and convincing. And two, then you'll need to use that for student cases as well. If you have a collective bargaining requirement that requires hearings, remember that you can have hearings as an option, and then again, you'll just need to align your Title IX policies with that. For union reps, so employees may be allowed to have both an advisor of choice and a union rep with them. If your collective bargaining agreement allows union representatives for any employees, then you can have both of those as an option. Again, just make sure that you're implementing whatever is in your bargaining agreements collectively, and then it's not in direct contradiction of Title IX, or you'll then need to do that or go back and look at those and renegotiate them. A few considerations for smaller districts that I just wanted to briefly touch on. One, supportive measures and remedies. Really important to get creative with these, because especially if you only have one class per grade or one class for English per grade, you're not going to be able to move students between classes. Academic remedies are going to look different. So think about how you can creatively look at that. I'd be happy to brainstorm with you individually, or a really great idea is to get together with students and with your employees and brainstorm ahead of time. Some ideas for avoiding conflicts of interest, like I mentioned before, consider partnerships with your ESD or with neighboring districts to share investigators, share adjudicators. Potentially consider external contractors. that can sometimes get expensive, so it's maybe not the most cost-saving measure, especially right now, but absolutely something to consider, especially if you don't have too many cases. Also consider double training so that you can avoid vacancies or you can avoid more conflicts of interest. You're also going to want to monitor from retaliation very closely, because in small districts, we know that the likelihood of retaliation, when it's hard to keep students apart or hard to keep individuals apart, could potentially go up, especially in small communities. So again, you're going to want to have more conversations with both the complainant and respondent around that, as you should be doing in any district, but more creative conversations and thinking about what are you concerned about? How can we mitigate this? The last thing I wanted to touch on is prevention and education. So there aren't really any prevention or education mandates in Title IX other than the notification requirements. So for students, what that means is they need to know where to report, who the Title IX coordinator is, and for staff and employees, they need to know where to report and that they have an obligation to report. However, remember, again, Oregon has state-based requirements related to prevention and education, like Aaron's Law. And I think it's really important to think about how your Title IX policies and processes can align well with prevention and education. So you have this requirement, for example, to not be deliberately indifferent. And when I think about that, I sometimes think that prevention and education and awareness programs can be a part of that non-deliberately indifferent response. If I, as the Title IX coordinator, am hearing that there's multiple incidents a year of students passing around pictures or of specific kinds of touching, specific kinds of rumors, that maybe tells me I want to think about prevention and education programs so that we can address that on a whole school level. It's not required, but I think it's a really great tool in your tool belt to think about your Title IX programs and a really holistic approach to this work. All right. So that's really briefly delving into some of the main issues around policies and processes and personnel. What's next for all of us? I'm sure that all of you are already thinking about how you can dive into editing these policies and how you can get more training to make sure you're in compliance by August 14th. If you have questions about this, about scheduling training or about other resources you can access, you just want to brainstorm with another thought partner, don't hesitate to reach out. This is my contact information, and I would be more than happy to chat with any of you about any questions. This concludes our webinar for today. I'm happy to stick around to answer a few more questions if needed. Otherwise, thank you for joining. Have a good rest of your day, and I look forward to working with all of you.